It is 3, 2, 1. Now you're good to go.
A very warm welcome to the virtual conference on the right to breathe clean air, health and environment-related sustainable development goals, hosted by Symbiosis Law School Pune, a constituent of Symbiosis International Deemed University, and sponsored by the Shastri Indo-Canadian Institute. The virtual conference is a two-day event specifically designed to discuss and deliberate on various interdisciplinary areas and core issues that are pertaining to the right to breathe clean air in light of the Sustainable Development Goals. A number of international perspectives and global best practices in tackling air pollution will be considered with the aim of charting a way forward. This conference is the result of the prestigious conference grant, which has been awarded to Symbiosis Law School Pune for the year 2020-21 under the Golden Jubilee Conference and Lecture Series grant from Shastri Indo-Canadian Institute after a nationwide competition. It is my honor to welcome esteemed guests and dignitaries who have graced us with their presence at this conference today. On our virtual dais today, we have our visionary founder and Honorable Chancellor of the Symbiosis International Deemed University, Dr. SV Musumdar, the Vice Chancellor, Symbiosis International Deemed University, Dr. Rajni Gupta, Director, Symbiosis Law School Pune, and Dean Faculty of Law, Symbiosis International Deemed University, Dr. Shashikala Gurpur, Director of the Shastri Indo-Canadian Institute, Dr. Prachi Jain, and our chief guest for the inaugural session, UN Special Rapporteur on Human Rights and the Environment, Associate Professor of the Institute for Resources, Environment and Sustainability, School of Public Policy and Global Affairs, University of British Columbia, Canada, Dr. David Boyd. I also extend a warm welcome to scholars, faculty members, and students who are joining us as presenters and attendees at this conference. In the course of the next 2 days, you will have the opportunity to hear deliberations and findings of international scholars, judges, and jurists on the topic of paramount urgency and of indispensable value, the right to breathe clean air. To deliver the welcome address, I would like to call upon Dr. Shashikala Gurpur. Dr. Gurpur is a Fulbright Scholar, Director of Symbiosis Law School Pune and Dean SIU. She's a former member of the Law Commission of India and awardee of the Karnataka government's annual Kittur Rani Chennamma Award in 2018-19. She's a member of the Curriculum Development Committee, Bar Council of India, Academic Council of the National Judicial Academy, Bhopal, IALS Global Law Deans Forum member, which is an international consortium of law schools, a member of the NCCIA Corporate Legislation Committee 2020 to 22. With more than 26 years of teaching experience, including tenures at NLSIU Bangalore, SDM Law College Mangalore, Manipal Institute of Communication Mahe, Manipal, and University College Cork, Ireland, Dr. Gurpur is listed as one of the 100 legal luminaries of India by LexisNexis. She has 72 scholarly articles and research papers, 2 co-authored books, and 12 book chapters to her credit. She has acted as an advisor to research projects and publications for Asian Network of Women in Communication, sponsored by WACC UK in 1999 to 2004. She is a distinguished member of the editorial board of LexisNexis Butterworth, Journal of IPR by CSIR, Law and Policy Journal, Dublin, Ireland, and the Polish Law Review. I invite you, ma'am, to deliver the welcome address.
Good morning, Honorable Chancellor, Sir, Dr. SV Musumdar, Sir. Good morning, Honorable Vice Chancellor, Dr. Rajni Gupta. And on this August dais, the esteemed representative of the Shastri Indo-Canadian Institute, Ms. Reshma Rana, and the chief guest of today's function, Professor David Boyd. It's my honor and privilege to welcome each and every one of you to this very, very special event. We are marking the beginning of a very important theme, clean air and the right to breathe clean air. Now, air occupies a very important place in Indian culture. Air, which is considered as equivalent to prana, although the idea of prana is much bigger than air, sits with the Indian culture of respecting all the elements of environment, especially when we talk about sacred grooves, sacred plants, the plants which are associated with clean air. However, it's a very contradictory dimension in our reality that today India is a home to 70% of world's most polluted cities. And India also accounts for 17% of the premature deaths related to bad air. We are at a juncture of time when we have seen recently United States of America expressing its support to Paris Convention. Now, at this juncture, we are deliberating on the anthropogenic causes of the obstacles to right to breathe clean air and anthropocentric dimension of the right. So far, if you look at Indian law and its alignment with the global dimensions of the right to breathe clean air, we see a very, very interesting dimension. The dimension comes from the fact that Indian law has been trying its best by its recent policy on the right to breathe clean air and a number of judgments. We are going to discuss it in the deliberations today and tomorrow, very aptly aligned with the Canadian timing and Indian timing. Tomorrow, the deliberations will be in the afternoon, and today it's in the morning with this inaugural. I first of all would like to welcome heartily our founder and esteemed Chancellor, Dr. SV Musumdar sir, who himself is a scientist of great repute and who has set an example with this tagline of Symbiosis, Vasudhaiva Kutumbakam. And true to the spirit of the whole world as one family, where environment sits as something which is not fettered by the boundaries, and showing our support to this theme in terms of our mission of the university as well. Sir, we are very inspired by your life, your message, and your work, especially with the Knowledge Village in Lavale, which is a home to huge biodiversity and a home to water conservation and clean air. Now, as one of the elements of Panchabhutas in Indian tradition, in the Hindu tradition, air quality has not been a great practical dimension for India. It's a dimension where we need to work. So as I welcome Ms. Reshma Rana on behalf of Shastri Indo-Canadian Institute being with us on the dais, I'm very happy to share, ma'am, that SICI has identified our endeavor in the right sense. What could be a better time in history than this moment to explore the interconnection of sustainable development goals as the humanity is coming out of a pandemic, which could be factoring with the concern for the environment in many dimensions. Probably it will come in the deliberations. As I welcome you, I would also like to share here, as we have audiences from all over the world, speakers from all over the world, that India has been identified as a home to one of the seven wonders, Taj Mahal, which was described by a national poet, Nobel laureate Rabindranath Tagore as a teardrop in the cheek of time. Now, this teardrop is fading because of air pollution. So that is also one dimension which makes the world to symbolically look at this right to breathe clean air. And I'm happy that SICI has honored us with this grant by looking at the proposal, which has a huge impact in terms of past, present, and future. I would like to state here that Symbiosis International University, one of the top 50 universities of our country, which is home to nearly 1,000 universities, and Symbiosis Law School, Pune, as one of its constituents, has been one of the top 10 law schools consistently in various surveys since 2000. Today, we stand as top 3 law school in India Today survey. And this is because of our innovative practices. Recently, we have been identified as the topmost institute in a competitive event by FICCI India in internationalization. So this event is a kind of metaphor for that, with such an esteemed panel and also the themes which cut across national and global dimensions. Our Honorable Vice Chancellor herself has been a leader of an institute which was theming on international business, but she was pivotal in developing the program that we have had, the dimension of the energy and environment coming into our management program, besides the law school having a mandatory curriculum on environmental law. So could there be a better forum than this? I also stand corrected here, although the picture reads as Reshma Rana, it is Dr. Prachi Jain, the director of SICI, who is with us. Madam, we are thankful to you for honoring us with this grant. So I would like to state here that this dais is a galaxy of superstars, especially with Professor David Boyd, who has been the rapporteur of United Nations aside from his career as an associate professor in this prestigious institute. The rapporteur has donned the role in leading reports on human rights and environment. So our theme neatly aligns with your lifetime work, sir. So we are very happy to welcome you. Our deliberations are very much sitting with our Advanced Research Center, SCALSER, which has got a cluster, interdisciplinary cluster on sustainability in focus, but it is more on rule of law in context connecting with SDG. So we want to build on this in terms of our another huge project, which is going to develop an exclusive multi-country transnational LLM program with almost a crore of grant from European Union. So we are going to have Southeast Asian countries and European countries bringing together their expertise in this LLM, which is going to be developed in 2 years' time. So this is an occasion for our students. You already see about 400 audience here directly, and we have more than 1,000 audience in the live streaming who are our students who are going to be benefiting out of this. Dr. Kaul, you'll be very happy to know that we are going to connect to curriculum, we are going to connect to research, and the important immediate outcome and impact of this event is going to be the resolutions which are going to come forth from our experts and panelists by tomorrow evening Indian time, when we are going to consolidate them, and we will be seeing that it will enter the periodicals of repute as research and policy documents in India and in the United Nations Forum, and also with Justice Emmanuel, who has been the President Justice in in the East African Environmental Court, and as one of the lead figures in Global Environmental Institute into the whole world. We and Africa share a common past and common present of not only of the post-colonial past, which we share with Canada as well, but also of comparing our lifestyles, our practices in terms of protecting the environment, of which air is a very important element. So here we have shared what Brundtland report said long ago, common future. Here we are going to have in that common future, the shared territories. So I'm sure that as an extended learning, as an expertise building and expertise sharing forum, as I welcome all of you, dear teachers, dear students, dear experts, dear scientists from India, from all over the world, within Symbiosis Law School, from sister law schools in Noida, Hyderabad, and Nagpur. I'm sure Dr. Ramandale, who is the director of our Noida Law School, who is here, would agree with me, are going to benefit out of this great forum. So it will also set an example to the next generation of students and experts that this is where, in the knowledge sharing fora that Symbiosis creates, that knowledge takes over power and knowledge becomes the power. So I'm sure that expertise, which is going to negotiate spaces for the betterment of the humankind through law, through policy, through scientific data and consensus building in this conference, would truly honor the initiative of SICI and the initiative of Symbiosis in this combined enterprise of knowledge. Welcome each and every one of you. And once again, I thank Dr. Kaul and her team for supporting us with this grant, and our Honorable Chancellor, Vice Chancellor, and our Pro-Chancellor, Dr. Vidya Ravdekar in absentia, for constantly supporting us in such endeavor. Welcome one and all.
Thank you, ma'am, for your fitting welcome address to this conference. Now, to deliver the Vice Chancellor's address, I would like to invite Dr. Rajni Gupta. Dr. Gupta is a distinguished academician and administrator who taught at international universities such as the Oakland University, Michigan, US, and Bremen University of Applied Sciences, Germany. She is one of 10 women selected from Asia to the Women in University Administration program sponsored by the US Department of State. She is the recipient of numerous awards such as the Lokmat National Education Leadership Award in 2015, the Swayam Siddha Puraskar by Lions Club of Pune Elite in 2015, the Iconic Leader Award Creating a Better World for All at Women's Economic Forum in 2017, and the Pune CKP Jeevan Gaurav Award in 2020, to name a few. It is an honor to have you with us today, ma'am. A very warm welcome to you.
Thank you, Lasya. Thank you for the introduction. Dr. SV Musumdar, the Chancellor of the Symbiosis International University and the founder of the Symbiosis, our esteemed guest this morning, Dr. David Boyd from the University of British Columbia, Canada. Dr. Prachi Jain, the Director of the Shastri Indo-Canadian Institute. Dr. Shashikala Gurpur, the Director of the Symbiosis Law School, Pune. Esteemed speakers from across the globe, from Canada, Tanzania, US, Germany, India, directors, faculty members, staff, and students. It gives me great pleasure to welcome all of you on behalf of the Symbiosis International University to this conference hosted by the Symbiosis Law School, a conference on the right to breathe clean air, health and environment related SDGs, which has been sponsored by the Shastri Indo-Canadian Institute. The Symbiosis International University, as you may know, is among the top 50 universities in India. As a university, we have 7 major disciplines that we offer programs in, ranging from management, law, engineering, humanities, media communications, and health sciences. We have about 18,000 students in all, and we have programs at the master's, bachelor's, as well as the doctoral level. As a university, we lay great emphasis on offering students an opportunity to learn beyond the classrooms. And as Dr. Gurpur rightly pointed out, conferences such as this provide a wonderful opportunity for students to listen to eminent speakers from across the globe. The Law School Pune is a flagship institute of our university and is ranked amongst the top 10 law schools in the country. This has been consistently so for the last several years. So Dr. Gurpur, all your hard work gets you those accolades, and we are very proud of the Law School of Pune. The topic for today's conference is indeed very, very relevant. And I think all of us are aware that the UN SDGs are a blueprint for achieving a better future for the people and for the planet. SDGs are a collection actually of about 17 goals, and within that there are around 169 targets. Air quality specifically is highlighted in 3 of those SDGs, which are connected to health and connected to the environment sustainability. Goal 3, which speaks about good health and well-being, has a specific target, 3.9, which refers to reducing deaths and illness due to air, water, soil pollution, and hazardous chemicals. 3.9.1 specifically speaks about reducing mortality due to household and, more importantly, ambient air pollution. I think all of us in India have been talking about air pollution, especially what we see in the northern part of the country, where because of the burning of stubble in the farms, air pollution has goes up tremendously during the winter months. This is something that is an area of concern, and I'm so glad that the conference will be deliberating on this. In addition to this, Goal 11, which talks about sustainable cities and communities, once again refers to good air quality. And here the focus is on waste management. How does one manage waste to ensure that cities are sustainable? Goal 12 again talks about responsible consumption and production. So in the process of production, if there are harmful substances which are produced, we need to reduce their release into the air. I think these are very, very important goals which a community needs to adopt and which a community needs to achieve. I'm really not sure whether 2030 is an achievable goal for all this for a country as large as India. However, very laudable goals, and I think each one of us needs to do our bit towards this. It's not enough to just say that the government needs to do something, but I do believe every organization, company, and individual needs to make sure that we abide by these goals which are meant for the benefit of humanity. I wish the conference every success. I'm delighted that you're going to be talking about themes such as global best practices in tackling air pollution, comparative law and policy towards approaches to right to breathe clean air, and also frameworks to establish and enforce a right to breathe clean air. I'm sure the next 2 days are going to have a veritable feast of speakers who will share their insights with you. And I wish the conference every success. Thank you.
Thank you, ma'am, for that pertinent address to set the stage for the conference on right to breathe clean air. Now, to deliver the Chancellor's address, we have with us Professor Dr. SV Majumdar, sir, founder and Chancellor of Symbiosis International Deemed University. Dr. Majumdar is the recipient of the high honor of Padma Shri in 2005 and Padma Bhushan in 2012. In 2016, Dr. Majumdar sir was conferred with the D.Litt by Tilak Maharashtra Vidyapeeth. He is also the recipient of the first Dr. APJ Abdul Kalam Memorial Award in 2016. He received the Punya Bhushan Award in 2009, the FIE Foundation Puraskar in 2006, the Maharashtra Gaurav Puraskar in 2003, the Top Management Club Pune's Excellence in Education Award, the Rotary Club of Pune's Service Excellence Recognition Award, to name a few. He has published over 50 original research articles in several national and international scientific journals. He's authored several books on life sciences and has contributed over 200 articles on science, education, and youth development. He has also been the chairman of the educational wing of FICCI from 2005 to 2006. It is an extreme honor to have you join us today, sir. A very warm welcome to you.
Thank you and namaste to all of you. Can you hear me?
Yes, sir.
Can you hear me?
Yes, sir, we can hear you.
Yes, sir.
Thank
Yes,
you
sir.
and namaste to all.
Namaste, sir.
Dr. Rajni Gupta, the
Namaste,
Vice
sir.
Chancellor of Symbiosis International University. Dr. David Boyd, Associate Professor, Institute of Resources, Environment and Sustainability, University of British Columbia, Canada. Justice Dr. Emmanuel, our own Dr. Shashikala Gurpur, directors, faculty, students, and invitees. Very good morning to all of you. I'm indeed very happy to participate in a very interesting and very purposeful conference on right to breathe clean air. And I'm thankful to Shastri Indo-Canadian Institute for sponsoring this particular conference. Thanks, Prachi Jain, for your support. For the last 11 months, India is passing through pandemic. There have been lockdowns, there have been restrictions, there have been so many hurdles regarding the movement, there are curfews, and I was wondering what will happen to higher education in our university. But I must congratulate all our heads and directors and vice chancellors for finding out innovative solutions to overcome the problems posed by pandemic. For example, this year, Symbiosis completed its 50 years. We are celebrating Golden Jubilee year. And so, a very ingenious way of celebration, because physical celebration was not necessary. And so, ingenious solution was found to organize Golden Jubilee lecture series, in which intellectuals, scholars, researchers, artists participated and delivered wonderful lectures. We even organized online literary festival. And I'm very happy that all our directors and Dr. Shashikala has found out a very interesting and innovative way of bypassing the hurdles posed by Corona and organizing such wonderful conferences, and that too at global level. I'm really happy, and I wonder how Shashikala could bring these stalwarts from US, from Africa, from Canada. Thank you so much, Dr. Shashikala, for your leadership and for your zeal and zest to defeat Corona and the atmosphere that Corona has created in the way of our progress. I'm really happy that in spite of all the problems and difficulties, our university is going ahead with academic programs. Be that as it may, I welcome our chief guest, Dr. David Boyd, on this occasion. The topic of this conference is really very touching as far as I am concerned, or in fact, all of us are concerned. Because for all these years, we have been taking many things for granted. We thought that we are getting clean water, clean air, clean food, clean milk. So, things which we are taking for granted are no longer to be taken for granted. And therefore, clean air is one such essential, life-saving entity which we have been taking for granted, but nowadays, because of industrialization, because of human interference, because of climate change, and because of so many other reasons, pollution especially, it is difficult to get even clean air, which should be the fundamental right of every, not only every human being, but every animal, I will say. I have taught botany for a number of years. And I used to teach my students that all animals, including human beings, are the guests of plants on this planet. Why? Because it is plants and plants alone which absorb carbon dioxide and give out oxygen. And oxygen is consumed by animals, including human beings, and they throw out carbon dioxide. And surprisingly, the carbon dioxide is again absorbed by plants, and with the help of sunlight and chlorophyll, photosynthesis, they convert carbon dioxide into carbohydrates. So this is a continuous, perpetual cycle which has been going on. Oxygen cycle, carbon dioxide cycle, nitrogen cycle. In fact, the nature is full of cycles. And it is the human interference which has put these cycles into jeopardy. And one such interference has resulted into a pollutant air, which is killing, as somebody said, more people than people who died because of Corona. As Shashikala just now mentioned, 30% of our cities are polluted. Now, we have to find out some solutions. And we have to perhaps take recourse of certain legislations. But there is another interesting thing, and that is yoga. Because in yoga, pranayama, that is oxygen. Oxygen is a pranamayu. There is a methodology in yoga to get clean air, clean oxygen inside. And therefore, yoga has been traditionally in our country, in our Patanjali Sutras, it's a way to take clean air, oxygen, which is so essential for human existence, for human man's good health. So these are so many aspects regarding clean air. I'm really happy that experts from different parts of the country, parts of the world, are going to deliberate on this very vital issue. And I will urge upon Dr. Shashikala. What happens is we hold seminars. We invite experts from different parts of the world. Sometimes I ask question to myself, what happens thereafter? What happens after the seminars are over? So there should be some way out to find out, saying the findings of this conference to the appropriate authorities, pursue those findings and see that those recommendations are implemented by our government or governments in different countries. I hope, Shashikala, you will see to it that the recommendations which emerge out of this conference go to the right authority and they are implemented so that this seminar becomes really purposeful and fruitful. I once again welcome the scholars and the researchers and the academia from different universities and different parts of the world. I wish you all the best. I wish the conference a great success. Thank you.
Thank you, sir. Thank you for your inspiring and encouraging words. Your vision and persistence on sustainability and growth encourages and guides us in all our endeavors. Thank you very much. Now, I would like to call upon Dr. Prachi Kaul, Director of the Shastri Indo-Canadian Institute, to deliver her address. Dr. Kaul served in international and national bodies like Plan International and National University of Education Planning and Administration before joining the Shastri Indo-Canadian Institute. She served as the program officer from 2004 to 2015 in SICI. She is a social scientist with keen interest in studying the aspirations and social mobility of the masses and its relation to higher education. Dr. Kaul serves on the advisory boards of a couple of academic and research institutions and joint working groups in between India and Canada on different domains. A very warm welcome to you, ma'am. Ma'am, could I please request you to unmute yourself?
That's the most frequently used statement, unmute yourself nowadays. So thank you so much, Dr. Gurupur, for having me here today. It's a very nice morning and very nice evening there in Canada. I thank all of you for putting this together, and my greetings to Dr. Majumdar, Dr. Gupta, Dr. Gurupur, and Dr. David Bloyd for joining us for this important session, which focuses on one of the important aspect of our life. And this is not just India or Canada or Africa, it's worldwide of equal importance. So thank you for putting this together. To begin with, I hope all is going well with you, your family, and fraternity of your institution in this time of pandemic. I hope all is well and will keep on going well. I wish you very healthy life from here on. So thank you so much. And Shastri Institute is, I would say, extremely proud to support this conference, which is Right to Breathe Clean Air, Health and Environment related to SDGs, that is being organized by Symbiosis Law School, Pune, under the umbrella of Symbiosis International University. I see a great participation, close to 500, and I'm sure most of this makes of student fraternity, which is the mandate that Shastri carries to build up the next generation of researchers and build up the personalities that can support the nation building and the world building. So I'm glad to see the attendance here, and especially as Dr. Gurupur also mentioned in her talk that most of it is comprising of the students. So that makes me really, really happy in terms of the outcome that I can see coming out of this deliberations. Sustainable development goals are very dear and close to Shastri Institute's programming. And starting from the time when, I would say Millennium Development Goals were introduced, we started our intervention and support in this direction. And coming from there, soon after the introduction of SDGs, we have integrated and imbibed the core of these into our activities. Pleased to share that every year in the last 6 years, in continuation, we have been organizing a Gala Binational Conference on this binational corridor between India and Canada on various sustainable development goals. Not just that, we have funded hundreds of academic events like this one happening right now, and extended fellowships and awards to carry out not just theoretical, but applied research and activities in all pertinent areas to SDGs. So I'm really proud to say that our last 5 decades, we are 50-year-old, 52 plus now, I would say, and have been dedicated and to increasing knowledge base on such issues. While there is no dearth of information on Shastri funded research projects conducted in India and Canada on these areas, a large number of these projects were really, really impactful in terms of their adaptation by the government, by the stakeholders and other organizations for the greater good of the communities in the respective countries of implementation. This particular event is happening on the binational corridor between India and Canada, of course, which are 2 great democracies of the world and have greater responsibilities to deliver, of course. And I'm personally delighted to see a great collaboration happening here amongst the institutions of excellence from India side, Symbiosis, and from Canada, UBC. I'm sure this connection will help you to take it forward, and in the time to come, there would be greater engagement that will lead to some beautiful outcomes. As Dr. Majumdar was saying, that we look forward to have a constructive outcome of any such event. And I'm sure the end of the event, we will have something to take forward, whether it builds up into the syllabi of the curriculum that you are going to propose for your student, or leading to further development of programs between India and Canada. So I'm sure this is going to build up knowledge base for both the ends. I congratulate you, Shashikala ji, for putting this together. I'm also pleased to share that starting from now, Shastri Institute have decided to focus on a couple of cluster-based issues involving major stakeholders. And these clusters are going to be right to breathe, of course, and apart from them, one health, sustainable habitat, agriculture, and umbrella of climate change. So there are going to be issues that we are going to discuss and take forward in a manner by which we will involve major stakeholders from India and Canada, whether it is federal government, provincial government, or state government, non-governmental organizations, educational institutions, and of course, community at large, which will help to build up this notion further and create an environment for sustainable development. Those who are not well aware about my institute, our mandate is to build academic and cultural relationship between India and Canada by undertaking programs and providing services that facilitate and sustain binational dialogue, understanding, and interaction. These relationships encompass both institutional as well as individual linkages. We are a binational organization with a unique mandate, which operates on 2 major directions, I would say. First is to serve as a financial support system for academic and research program in terms of offering fellowships and other awards in both India and Canada. And secondly, it is a binational network of leading academic institutions, which are kind of a knowledge partner in generating linkages and collaborations. Our awards and programs provide opportunities for recipients to gain first-hand experience in India and Canada. Of course, this is the pandemic time, so mobility is on hold. Otherwise, mobility is an integral part of our programming. So soon after the COVID time is over, we will restart the mobility of our scholars from India to Canada and Canada to India. Of course, through our vibrant intellectual activities, we are trying to engage high-level interactions like this one between our member institutions in both the countries. It's a unique in itself to have 116 premier academic institutions as member from India, including all first to second generation IITs, IIMs, and ITs law schools, central and state university. Symbiosis has recently joined the membership, so I welcome them wholeheartedly. And 39 universities of excellence from Canada, all sizes and specialization. So in being a key organization interacting between this space, wherein government, academia, and business community is involved, we have provided and enhanced opportunities to academics and research fraternity for our member institution. We focus on our people. We focus on fostering strong talent and to develop intellectual and cultural linkages, which increase in turn, the research outcome, quality of life, and long-term relationship. The same is my aspiration for this event, and I'm sure we are going to have great deliberations over the period of time, and I'm confident that this important forum will provide our intellectual community a wonderful opportunity to understand diverse perspective to bring about changes, no matter how subtle they are in their immediate environments. So wish you all the very best, and I look forward to to hear more on what were the outcome and how we are taking it forward. Thank you so much from Shastri side. Thank you.
Thank you very much, ma'am, for your address representing the Shastri Indo-Canadian Institute. We highly value this collaboration with you.
Thank you.
It is now my privilege to call upon the chief guest for this inaugural session, Dr. David Boyd. Dr. Boyd is the UN Special Rapporteur on Human Rights and the Environment. He is an Associate Professor of Law, Policy and Sustainability at the University of British Columbia. He is the Executive Director of Eco-Justice, appearing before the Supreme Court of Canada. He has advised many governments on environmental, constitutional, and human rights policy and co-chaired Vancouver's effort to become the world's greenest city by 2020. He's a member of the World Commission on Environmental Law. He's an expert advisor for the UN's Harmony with Nature initiative and a member of the E-Law, the Environmental Law Alliance Worldwide. He's an author of 9 books and over 100 reports and articles on environmental law and policy, human rights, and constitutional law. Books include The Rights of Nature, ECW Press 2017, and The Optimistic Environmentalist in 2015. We are so honored to have you join and address this conference, sir. A very warm welcome to you.
Thank you very much, Razia. And Honorable Chancellor, Honorable Vice Chancellor, Honorable Directors and Doctors, I am absolutely delighted to be serving as a guest at this vitally important and timely conference hosted by Symbiosis Law School Pune and sponsored by the Shastri Indo-Canadian Institute. Ladies and gentlemen, imagine this. Imagine that a terrible scourge was sweeping across the earth, killing millions of people, making tens of millions of people seriously ill, adversely affecting the quality of life of billions of people and causing trillions of dollars in economic costs. Surely such a scourge would be treated as a global emergency, prompting intense research for solutions, prompting strict government regulations, and causing dramatic changes to reduce the extent of the damage and prevent future damage. Ladies and gentlemen, I am not talking about the COVID-19 pandemic. As terrible as the toll of the coronavirus has been in the past year, it pales beside the annual destruction being inflicted upon people by air pollution every year, year after year. Since the start of the COVID-19 pandemic, more than 2.5 million people have died, including approximately 160,000 deaths in India. But since the year 2000, Approximately 140 million people have died because of air pollution from a combination of heart disease, stroke, respiratory illnesses, and lung cancer. 140 million people. The number is so mind-boggling that it's almost unfathomable. This horrible statistic includes more than 10 million children under the age of 5 who have died in the past 20 years. As a parent, I honestly cannot imagine the pain that would be inflicted by the loss of my beautiful daughter to polluted air. Recent scientific research also reveals that exposure to air pollution raises the risks of adverse birth outcomes, such as low birth weight and preterm birth. Exposure to air pollution also impairs neurological development in childhood and contributes to neurological disorders, such as Alzheimer's disease and Parkinson's disease. Another key fact to consider is that risks related to air pollution are unfairly distributed. Among the most severely harmed are children, women, the elderly, minorities, indigenous peoples, people living in poverty, people with pre-existing health conditions, and people who fall into several of these categories. In states where household air pollution is prevalent, women suffer the highest levels of exposure because of their primary role in cooking. And yet the world has turned a deaf ear and a blind eye to this ongoing catastrophe. The United Nations has recognized the right to clean water, but has never even debated the right to clean air. Dozens of national constitutions around the world explicitly recognize the right to clean water. 0 constitutions explicitly recognize the right to clean air. When I began serving as the United Nations Special Rapporteur on Human Rights and the Environment in 2018, I was shocked to learn that the World Health Organization never mentions human rights when discussing air pollution. The United Nations Environment Assembly passed resolution after resolution on air pollution, but never mentioned human rights. And so I decided that for my first annual report to the United Nations Human Rights Council, I would tackle the right to breathe clean air in March of 2019. My report outlined the problem, the human rights obligations, and 7 key steps that all states should take to fulfill their human rights obligations by reducing air pollution to acceptable levels. First, states must monitor air quality, and many states, including India, told me they have expanded or are planning to expand their air quality monitoring infrastructure. Second, states must identify the main sources of air pollution, which vary from nation to nation and regionally within nations. For example, the main source could be household air pollution or coal-fired electricity generation or transportation emissions. And I know that agricultural burning is a major issue in India, but ranking sources is a vital prerequisite to determining priorities for action. Third, states must engage the public, offering education about the causes and consequences of air pollution, providing information about the levels and sources of air pollution, and enabling public participation in decisions that could affect air quality. States must also ensure that people have access to justice and effective remedies in cases where their rights are being violated or threatened. Fourth, states must enact laws, regulations, and standards to create legally binding and enforceable limits on air pollution. Fifth, states must develop national air quality action plans with timelines and specific measures to be taken to improve air quality. Sixth, states must implement and enforce these plans, laws, regulations, and standards by allocating adequate resources. And this is where India faces challenges in the implementation and enforcement. And seventh, states must evaluate progress, and if it is not satisfactory, must revise their plans to be stronger and more expeditious in achieving the air quality standards. My reports to the United Nations also contain extensive examples of good practices in each of these 7 categories. Because air pollution is a preventable problem. Household air pollution can be largely solved by replacing polluting cook stoves with clean cook stoves. And India, to its credit, has done this on a large scale, although more remains to be done. Fossil fuels have powered society since the Industrial Revolution, but that era is coming to an end as we replace these dirty sources of energy with clean, renewable sources of energy. Internal combustion engine vehicles are being replaced by electric vehicles. Cities built for cars are being replaced by cities built for people. And as China is demonstrating, the nations that grasp the opportunities presented by these historical transitions will create millions of jobs and trillions of dollars in wealth. And ladies and gentlemen, taking these actions to tackle the global air pollution crisis will also go a long way toward addressing the global climate emergency and achieving the Sustainable Development Goals. In our more detailed remarks, approximately 1 hour from now, I will discuss how the emergence of the right to live in a healthy environment has the potential to serve as a catalyst for the transformative changes that humanity must make to ensure that everyone, everywhere, can breathe clean air. Thank you very much, and I look forward to the remainder of this terrific event.
Thank you very much, sir. Thank you for that stirring and urgent message that you have communicated with our audience today. With this, we come to an end of the inaugural session, and we will be moving on to the first plenary session. But before that, I would like to take this opportunity to extend a heartfelt gratitude to all the dignitaries for taking time from your extremely busy schedules. I would like to thank the top management of Symbiosis International Deemed University, Dr. SV Musumdar sir, Dr. Rajni Gupta ma'am, and our Pro-Chancellor, Dr. Vidya Yaravdekar, for their vision and constant support rendered by you to our institute. I would like to thank our dynamic leader, director, and dean, Dr. Shashikala Gurpur, for her tenacity in pursuing valuable international collaborations and academic excellence. A special note of thanks also to the representative from the Shastri Indo-Canadian Institute, Dr. Prachi Jain, and our chief guest, Dr. David Boyd, for graciously accepting our invitation and presenting such erudite views on the topic. Thank you all very much. We will now quickly move on to the first plenary session on the theme Right to Clean Air and its significance for SDGs. Each of the speakers of the plenary sessions have been allotted a time of 20 minutes each to present their views on the topic, and it will be followed by a 10-minute question and answer session. In order to assist the speakers and also in view of keeping the timeline, an indicative bell will be rung 5 minutes prior to the conclusion of your time. The speakers are then requested to conclude their deliberations in order to afford adequate time to all the speakers on the panel. To introduce the theme, I would like to once again call upon Dr. Shashikala Gurpur, ma'am, Director, Symbiosis Law School, Pune, and Dean, Symbiosis International Deemed University. Over to you, ma'am. Could I request you to please unmute yourself?
Panelists and I think some of our guests from the initial function, especially our Honorable Chancellor Sir is also there among the listeners. A very warm welcome to each and every one of you, and namaskar. So the first theme is going to interlink Sustainable Development Goals and Right to Clean Air. Already our Honorable Vice Chancellor in her introduction connected some of the goals. I'm very sure that our two honorable speakers who are going to don the panel now, one is going to be Professor David Boyd and the other is going to be Ms. Engel. Definitely they are going to speak at length. So my initial proposition is to set a kind of background. Sustainable development goals have been closely followed by India, and internally we have taken many measures. Although our immediate response has been in the Rio +20 kind of principles, the different goals which already have been briefly introduced by Vice Chancellor Madam, particularly Goal 1, Goal 2, Goal 8, Goal 11, Goal 12 are connected, which I'm sure that Professor Boyd is going to highlight and Ms. Kirsten Engel is going to highlight, the senator from Arizona. But I thought that I will only talk about how, as far as India is concerned, these goals have been connected. I thank my research student and intern, Mr. Akash for providing us this research. As I already told you, the magnitude of the problem of lack of clean air or threat to clean air in the form of pollution has been a concern in India for very long, ever since we had the infamous Bhopal gas tragedy. and also our lack of industrial, we can use the word vigilance. Although it is so, we were one of the first countries to have a very strong Air Pollution Prevention and Control Act, which had environmental justice in the form of criminal justice measures for those industries who were violating standards to create pollution. So polluter pays principle and polluter gets penalized kind of principle was there. But what was interestingly missing or weak was the ensuring of punishment for those who fiddle with the quality of air or who fiddle with the preservation of clean air. Our Bhopal experience itself showed, as the world has spoken about it, in terms of an integrative approach to clean air, we have fallen short of the ideal standards. Whether it is the question of punishing the wrongdoer in terms of the human brain behind the fictional corporation, the Union Carbide, whether it is the question of licensing this kind of a factory and allowing the shanty towns to grow around it, whether it is the question of compensating in the post-disaster period, we have a long way to go, was the clear statement that came after that. Now, in comparison, we have got the way in which our legislation has been talking about way back in 1981, which came as an offshoot of our compliance with the Stockholm Conference of United Nations Organization in 1972. However, in the Rio 20 plus era also, we've been making piecemeal efforts. Our Pollution Control Board, our environmental impact assessment in terms of pre-assessing the environmental impact and post establishment of the industry, the compliances to be done, we have been little relaxed in our approach. Now, this is where the integrative approach in terms of connecting sustainable development goals and aiming at right to clean air has been an agenda which is unfinished, whether it is our legislation or our policy. A lot of handling of this issue, like in Canada, has been between state and provincial government, the federal and the provincial governments. And secondly, because of that, because of the immediate powers that the state pollution control boards have in our approach in terms of conserving the air quality and preventing intervention with the air quality has always come before our courts. So tomorrow's session will see our Green Tribunal judge coming and talking here. You will get more ideas as audience and as experts to listen to. However, when it comes to what Professor Boyd spoke about, in terms of environmental emergency, we had a lot of difficult developments which our judiciary had to confront. We had the issue of clean environment as a right, as part of right to life, under Constitution's most sacrosanct provision of Article 21 being emphasized in number of judicial decisions. Way back in 1993, in the Consumer Education Forum case itself, Supreme Court highlighted. Then we had the Vellore Citizens Forum case. And then we had where the principle of polluter pays has been highlighted. We had the next case, the series of MC Mehta cases about water pollution and about general environment pollution and the threat to Taj being questioned. So again, Supreme Court highlighted it. However, our recent decision in terms of stubs burning, as our Vice Chancellor highlighted in the northern India, which is a kind of farming practice causing the pollution, particularly in the wheat harvesting season, which coincides with the Diwali season. So whether our bursting of crackers is the cause or is it only a correlative with the stubs burning is still an unresolved mysterious question. However, Justice Chandrachud in the forefront of the decision while disallowing the bursting of crackers during Diwali said that crackers can wait, but environment is a priority. So this is, and human life is a priority. So this is where we see competing causes of threat to the right to breathe clean air need to be seen in an integrative fashion, in an interrelated fashion. For example, scientific data shows that more than 57% of air pollution is caused by industrialization, and industry's poor compliance with the preventive measures, protective measures. About 16% of it comes from household usages, especially the biofuels and other kinds of plant-based fuels and burning of fuels, and industrial pollution also includes our thermal energy corporations, which use coal. The coal ash has also been a primary cause of air pollution in India. But if you look at this whole blame on stubs burning or indoor practices of cooking with the biofuels, or if you look at even cracker industry, they do not account for more than 16 plus 7% of air pollution causes or intervention with the right to clean air. Whatever is the cause, the consequence is, as Professor Boyd said, something which calls for national emergency or global environmental emergency, and the right to health as part of right to life, which is at the epitome of fundamental rights as the most sacrosanct right, is also under threat. Now, it is here that innovation in terms of our R&D mechanisms within the industry, both in terms of IP creation and in terms of new technology, need to be looking at the health infrastructure and focusing on less polluting or less interfering with clean air kind of technology. So when we put a human being and human life in the center, everything has to revolve around that than prosperity at the expense of human life. So some of the global South countries are fiddling with this dilemma. I'm sure that Justice Emmanuel, who is here, would share this sentiment. Our right to development to be balanced with our right to life, connected to right to health, connected to right to environment, of which right to breathe clean air is a significant part. Therefore, because of 70% of the globally highly polluted cities being located in India, and this number increasing in last 2 decades, and premature deaths coming from certain highly polluted parts of India, and our commitment to reduce pollution even in a policy document is coming nowhere closer to Canada's avowed standard. I think there is a lot to learn from best practices from other parts of the world. And I'm sure that our African counterparts will share the sentiment, and our American resource person who is also a legislator. We have members from legislation, judiciary, as well as United Nations talking here, aside from our academic ideas, would definitely bring a lot of insights to the table. So I'm very glad to introduce the team, and I'm also very happy to welcome on behalf of the organizers, Professor Boyd, Professor Kirsten Engel, who is also the senator here, aside from all other audiences and experts here. I thank my team for putting together, especially Professor Rupal, Professor Mohanty, Professor Raj, for the great hard work that has gone behind the curtains in bringing these resource persons and making this possible. Welcome, one and all.
Thank you, ma'am, for your erudite comments and findings in introduction to the theme of right to clean air in an Indian as well as international context. Now to move on to the next speaker and to speak on the theme, right to breathe clean air and sustainable development goal, the role of the judiciary. I would like to invite Justice Dr. Emmanuel Ugirashabuja, immediate past president of the East African Court of Justice. He is currently the Dean Emeritus of the National University of Rwanda Faculty of Law, a member of the Global Judicial Institute on the Environment, supported by the UNEP and IUCN, a member of the governing board of the International Association of Law Schools. His lordship is an arbitrator and an expert in both national and international arbitrations. He is the member of the Superior Council of Judiciary and the Supreme Council of Prosecution, member of the team of experts in the East African community on fierce challenges and concerns towards the East African Political Federation. He's also the legal advisor at the Rwandan Environment Authority and the Rwandan Constitution Commission. He has delivered lectures at the University of Edinburgh, the University of Dar es Salaam, to the Rwanda Senior Command and Staff, and at the Rwandan National Police College. It is an high honor, sir, to have you once again with us. A very warm welcome to you.
Thank you very much for that introduction. I hope you can all hear me.
Yes, sir.
Okay. It gives me great pleasure to be invited to give a presentation on this important topic of right to breathe clean air. I wish to commend the leadership of Symbiosis Law School for the stewardship in the debate on diverse subjects of law relevant to the 21st century. In December last year, let me begin with this story about what happened in December last year. In December last year, in a landmark decision, a coroner in the United Kingdom concluded that a young girl known as Ella Ado Kisi Debra, who lost her life to a fatal asthma attack aged 9, died largely due to air pollution, which was a significant contributory factor to both the induction and exacerbation of her asthma. Ella became the first person in the United Kingdom to have air pollution officially recognized by a coroner as a cause of death. An earlier inquest ruling from 2014, which found that she died of acute respiratory failure, was quashed by the High Court of England and Wales, following new evidence about the dangerous levels of air pollution close to her home, and this led to a new inquest. Deputy Coroner Philip Barlow found that Ella was exposed to levels of air pollution that were above legal limits for nitrogen dioxide and above the World Health Organization guidelines for particulate matter, which United Kingdom law had not yet reflected. He concluded that her exposure to this excessive pollution contributed to the asthma that led to her death. According to the coroner, the way to school for Ella was clogged by a thick cloud of toxic pollution from the South Circular Road in London. The coroner also recognized that vehicles were the main source of the pollution that contributed to her death. The coroner further said that the failure to reduce pollution levels to legal limits possibly contributed to her death, as did the failure to provide her mother, that's the mother of Ella, with information about the potential for air pollution to exacerbate asthma. He went on to say that during Ella's life, nitrogen dioxide emissions in Lewisham, where she lived, exceeded legal limits, both those set by the European Union and the national levels. Particulate matter levels were above the World Health Organization guidelines, he said. And we are talking about the United Kingdom. We haven't even started talking about what happens in the third world countries. And this is last year in December 2020. This groundbreaking decision could pave the way for other individuals to use the law to fight for their right to breathe clean air. For the many people who suffer as a result of breathing the polluted air around them, the possibility of making the link between excessive pollution and damage to their health in a court of law now seems a possibility. Generally speaking, while judges are not bound by reasoning set out by the coroner, and any case will depend on its specific circumstances, I do believe that the result of this inquest signals that our current scientific knowledge of the impacts of air pollution could be strong enough to establish a causal link in courts. The inquest into Ella's death has highlighted the government's legal duty to protect people's lives from the threat of air pollution. The story of Ella is the story of many girls, boys, men, and women around the globe. Pollution levels have been the cause of untimely death, and yet the deaths have been attributed to acute respiratory failures. The Ella story also reveals that many governments are far from committing to legally binding laws to achieve the World Health Organization guidelines. According to the World Health Organization, air pollution is a major environmental risk to health. By reducing air pollution levels, countries can reduce the burden of disease from stroke, heart disease, lung cancer, and both chronic and acute respiratory diseases, including asthma. According to the World Health reports in 2016, air pollution is the fourth greatest overall risk factor of human health worldwide, after high blood pressure, dietary risks, and smoking. The World Health Organization further notes that the ambient outdoor air pollution in both cities and rural areas accounted to up to 4.2 million premature deaths worldwide per year in 2016. This mortality is due to exposure to small particulate matter of 2.5 microns or less in diameter, which cause cardiovascular and respiratory disease and cancers. Addressing all risk factors for non-communicable diseases, including air pollution, is key to protecting public health. Air pollution is linked with many of the United Nations Sustainable Development Goals. Air pollution is recognized as a pressing sustainable concern and directly mentioned in 2 SDG targets. That's the SDG 3.9, which deals with substantial reduction of health impacts for hazardous substances, and SDG 11.6, which deals with reduction of adverse impacts of cities on people. Air pollution, with its adverse impact on health, as can be indisputably shown by science, is transforming how lawyers and judges address cases involving pollution. The vital question relevant to this presentation is, what role does or can the judiciary play in ensuring that the right to clean air is protected, thereby ensuring a safe and just space for humanity? It has been uttered time and again that judiciaries have neither the sword or the executive nor the purse of the legislature, but merely judgments. The role of the judiciary is limited to application of the law to cases brought before the courts. Judges can contribute to ensuring that the right to clean air is preserved and protected. The judges are central to, first, holding governments accountable for meeting policy commitments and complying with legal obligations on clean air, the environment, and sustainable development, and thereby shaping legal and policy frameworks. Second, judges are central to admitting relevant and credible scientific evidence for pollution in courtrooms and making judicial findings of fact about pollution, which can elevate the national discourse on the right to clean air. Indeed, courts have successfully incorporated international scientific consensus synthesized by World Health Organization into domestic legal common ground, ensuring that advancements in pollution filter into local discourse. The third important central role of judges is balancing outcomes and protecting citizens' fundamental constitutional and other legal rights, frequently closing the gaps through which people and ecosystems fall. On a practical point of view, let me illustrate to you how environmental cases have come before the courts. The first way that environmental cases have come before the courts is through constitutional rights litigation. A number of constitutions have an explicit right to environment now, especially in this part of the world. Others have provisions which have an implied right to a clean environment, and where this right can be inferred from. Due to time limitations, I'll deal with cases where environmental rights have been extrapolated from existing human rights. In the famous Atakoya versus the Union of India case, which I like citing in most of these presentations, the High Court of India held that the right to sweet water and polluted water attributes to right to life. From these are the basic elements which sustain life itself. And it was dealing with Article 21 of the Indian Constitution. It is very clear that from this you can further extrapolate that the right to breathe clean air can be extrapolated from the right to life, as was done in the Atakoya versus the Union of India case. In the Social and Economic Rights Action Center and the Center of Economic and Social Rights versus Nigeria, a case famously referred to as the Ogoniland case, A regional court, the regional court, which is the African Court of Human and People's Rights, which has human rights jurisdiction over African countries, including most of the Commonwealth countries, held the view that if environment is degraded by pollution and it affects the quality of life and safety of life protected by such rights as the right to life and the right to health, the right to satisfactory living conditions, then the rights themselves are breached. Thus, the right to clean environment can be extrapolated from existing rights. No one captures the nexus between human rights and environment than Judge Wiramanti of the International Court of Justice, who in a separate opinion in the Gapchigovo-Nagimaros case, opined that the protection of the environment is likewise a vital part of contemporary human rights doctrine, for it is a sine qua non for numerous human rights, such as the right to health and the right to life itself. It is scarcely necessary to elaborate on this, as damage to environment can impair and undermine the human rights spoken of in the Universal Declaration and Human Rights Instruments. This is a quote from Judge Wiramanti of the then judge of the International Court of Justice. The view espoused here is that human rights, including the right to clean air and fundamental human rights, are intertwined, and decoupling fundamental rights from environmental rights is simply unrealistic and would not be in the best interest of protecting the fundamental rights we deeply cherish as a society. The general comment number 36 of Article 6, Right to Life of the International Convention on Civil and Political Rights, published by the United Nations Human Rights Committee in 2019, is crystal clear that the protection of environment is a vital part of the right to life. The general comment provides in its paragraph 62, and I quote here, that environmental degradation, climate change, and unsustainable development constitute some of the most pressing and serious threats to the ability of the present and future generations to enjoy the right to life. The obligation of state parties under the international environmental law should thus inform the content of Article 6 of the Covenant, and that the obligation of state parties to respect and ensure the right to life should also inform their relevant obligations under international environmental law. Implementation of the obligation to respect and ensure the right to life, and in particular life with dignity, depends inter alia on measures taken by state parties to preserve the environment and protect it against harm, pollution, and climate change caused by public and private actors. State parties to the ICCPR should therefore ensure sustainable use of natural resources, develop and implement substantive environmental standards, conduct environmental impact assessments, and consult with relevant states about activities likely to have a significant impact on the environment, and provide notification to other states concerned about natural disasters and emergencies and cooperate with them, and provide appropriate access to information on environmental hazards, as well as pay due regard to the precautionary principle. Action in torts. This is the second way that cases come to court is by way of actions in torts. This is the most common and traditional way that environmental cases have been brought to courts, especially in common law jurisdictions. Actions in tort law generally include a nuisance, negligence, and trespass. In action, pardon me. Actions in tort generally include nuisance, negligence, and trespass. In action in torts, parties generally seek damage and or injunctions to stop particular actions which specifically affect them, and by extension, degrade the environment. Historically, standing I don't know whether you can still hear me.
Yes, sir, we can hear you.
So sorry, I thought I was lost. You had lost me for a moment.
Yes,
okay.
sir, we lost connection, but we can hear you now, sir.
Okay, thank you. Yeah. Historically, standing rules in action in torts have tended to limit access to courts unless the plaintiff can show a property of financial interest. Nuisance has generally been defined in a number of cases at common law as an indirect interference with a person's land or enjoyment of land because of noise, smell, air pollution, or water pollution. And public nuisance has been defined as an activity which materially affects the reasonable comfort and convenience of the public. Another way, the third way that environmental cases come to court is by actions challenging government authority or actions. This includes actions challenging government. Action also includes inaction or delay. A number of legal issues unique to this type of litigation include the standard of review, the amount of difference given to court in reviewing the decisions of government and its agencies, for example, environmental agencies. And over years, courts have adopted a systematic balance analysis, which includes a high standard of consideration of environmental factors, a standard which must be rigorously enforced by reviewing courts. Another important aspect of actions challenging government's actions is scope of review. This involves the extent of judicial review of government in environmental matters. And then there's the aspect of time frame of review. And in other words, dealing with the statutory time limitations of reviewing government actions. Most of these issues are provided for either broadly or restrictively in national legislation. The final way that environmental cases come to court are through criminal prosecutions. Criminal prosecutions maximize deterrence message. Remedies often include imprisonment or heavy fines. The standard of proof obviously is beyond reasonable doubt and is more demanding than the civil standards. Most environmental crimes require proof of a pollution event and proof of criminal intent. In most cases, the government proves that the intent of pollution by showing that the defendant acted knowingly. That is, the government must show voluntary and intentional conduct, not conduct that is the result of an accident or mistake of fact. For other crimes, such as crimes involving asbestos removal or pollution from ships in international waters, the international failure to comply with workplace safety standards or the intentional falsification of records may be what drives the analysis of intent. In dealing with the environmental matters, courts have been faced with certain procedural challenges. The first one is access to court. And when I'm talking about access to court, I'm looking at issues of standing rules. And the question is, are they restrictive or broad? Are public interest litigation, axio popularis, or class actions permitted in a given jurisdiction? Are there financial and technical barriers to access the courts? For example, is the court at liberty to invite experts or to admit friends of the court, that is amicus curiae, who specialize in environmental matters? Is there legal aid or technical assistance with evidence? Historically, standing rules have tended to limit access to court unless the plaintiff can show a property of financial interest. Increasingly, the right of the public to participate in environmental matters is viewed as a fundamental notion of justice and essential to the rule of law. Principle 10 of the 1992 Rio Declaration on Environment and Development seeks to ensure that every person has access to information, can participate in the decision-making process, and has access to justice in environmental matters with the aim of safeguarding the right to a healthy and sustainable environment for present and future generations. Courts nowadays have over time tended to be liberal when it comes to standing in environmental matters, even where the law is silent. I can give you a few examples here. In the Environmental Action Network Limited versus the Attorney General and the National Environmental Management Authority of Uganda, the Environmental Action Network sued the government seeking protections from smoking in public places. The Environmental Action Network contended such measures were required for the general good of public health in Uganda, and to enforce the right to a clean and healthy and the right to life. The Honorable Principal Judge of that court, Mr. Justice J.H. Nabgoba, as he was then of the High Court of Uganda, held that Article 50 of the Ugandan Constitution did allow public interest litigation by the plaintiff, given the interest of public rights should transcend procedural technicalities. In the R versus Her Majesty's Inspectorate of Pollution Greenpeace Limited, number 2 of 1994, it was held by the High Court of England and Wales that nonetheless, the applicant had sufficient interest in the issues raised for it to be granted locus standi. Its supporters may not have an effective opportunity to bring an action individually, and it was entirely appropriate that an established body with genuine interest in the issue should do so on behalf of its members. In Oposa versus Factoran case in the Philippines, the standing for class actions and future generations was relaxed. The Philippine Supreme Court recognized the petitioner's standing to file a class suit for themselves, for others, or even for the generations to come. Such standing stemmed from the petitioner's right to a balanced and healthful ecology. In contrast, in the Friends of Ireland, in the Friends of the Irish Environment versus Single County Council, the High Court of Ireland found that an applicant lacked standing to challenge a court's decision to issue an airport authority a 5-year extension for planning permission to construct a new runway because there was no right of participation under the planning law. Further, the applicant could not demonstrate any disproportionate interference with the right to clean environment. Another issue that courts have to contend with in terms of challenges when cases come before the court is the principle of forum non-convenience. In law, the term forum non-convenience refers to the discretionary power of a court to not hear a case that may be more appropriately or more conveniently heard in another court. The exercise of forum non-convenience results in the dismissal of the case, but does not prevent the plaintiff from filing the case in a different court, usually the one the original court recommends. In the case which was earlier referred to by Professor Gurpur, the Reunion Carboid Corp gas plant disaster before the Southern District of New York court in 1986. The origin of this case goes almost half a century ago, when construction of the pesticide plant began in the lakeside town of Bhopal in the Indian state of Madhya Pradesh. The American-owned Union Carbide Corporation, within the thriving chemical industry, focused its attention on the Indian subcontinent. Irregularities culminated in the disaster on the night of the 3rd December 1984, when a toxic gas leak from the tank E610 in the methyl isocyanate plant got out of control. The deadly chemical cloud was quickly blown by the wind to the densely populated neighborhood next to the railway station. The controversy as to the exact number of deaths that occurred that night still continues today. And although UCC acknowledges 3,800 deaths victims, association and impartial investigators estimate over 8,000 deaths and at least 150,000 injured. Forum non-convenience was applied in the case before the Southern District of New York court. It was determined by the court that the Indian courts were considered more adequate for trying the case, thereby avoiding all the evidence maintained by Professor Galanta about why it was important to have the case treated in the Southern District of New York. In another recent case in Africa, in the case of Lungoa versus the Vandata resource before the United Kingdom courts, both the High Court and the Court of Appeal grappled with the question of the appropriate forum to deal with a case involving 1,826 Zambian nationals against the Zambia-based Konkola copper mines and its London-based parent.
Emmanuel, sir, excuse me for intervening.
Yes.
We are running short of time and because of time constraint. So if you can
Yes.
wind up in 1 minute, sir. Please.
Yes,
Thank
yes,
you.
yes. Thank you so much. Let me also, skipping this case because the Court of Appeal and of England and Wales ultimately determined that they have the jurisdiction under the new rules of the Brussels rules. The idea was that the courts cannot use the courts in Europe cannot use the principle of forum non-convenience to entertain a case before the court. So some of the principles that we've used, and I don't have the time to go deep into this, to deal with these cases, one of the most important principles now being used in courts is that of in dubio pro natura. And in this principle, the courts have decided that in future, when faced with cases involving environment, the courts should give preference to a decision which will be in favor of environment, even where you have doubt in terms of the science provided before you. And this is quite closer to obviously precautionary principle. In conclusion, let me say this. All of us judges operate within territorial bounds defined by rules of jurisdiction. And each jurisdiction has its own distinct history and culture and its own constitutional treaty arrangement and institutions. However, this does not stop us from sharing experiences as judges in order to be able to look at best practices of dealing with these cases, especially those to do with the right to clean, to breathe in clean air, which is the subject matter of today's presentation. Let me conclude by again saying that the ongoing efforts of the Symbiosis Law School to shape and improve the discourse on important subjects of law are impressive. It is a great endeavor you all undertake, and I do take this opportunity to wish you well with it. Thank you very much, and I hope to share my paper so that you can get into details of what I wanted to present today. Thank you very much once again, Professor Gurpur.
Thank you very much, sir, for bringing in the judiciary point of view on the right to breathe clean air, and also for unraveling the significance of this right from the contemporary human rights perspective. This is a reminder to the participants that they may post their questions to the speakers of the plenary session in the chat, which will be taken up towards the end of the session. Now, to speak on the topic of the emergence and evolution of the right to a healthy environment, implications for a clean air, I would like to invite once again Dr. David Boyd, UN Special Rapporteur on Human Rights and Environment. Welcome, sir.
Thank you very much, Lazia. And as I mentioned earlier, it's really a great honor to be participating in this conference on the right to clean air presented by the Symbiosis Law School. And I was really pleased to hear Mr. Justice Emmanuel Ugira Shibuja discussing the story of this young British child, Ellie Kissy Debra, whose death was caused by air pollution, as a coroner determined last December in the United Kingdom. It's a very powerful story that really puts a face on this unfathomable magnitude of premature deaths from air pollution. I want to share with everyone today the story of one of the most important human rights of the 21st century, the right to live in a safe, clean, healthy, and sustainable environment. You know, scientists estimate that there are 100 billion planets in the Milky Way galaxy and more beyond in the universe. But despite the best efforts of generations of scientists, there is only one planet that we know supports life, Earth. This beautiful blue-green planet is a miracle filled with amazing natural wonders. Unfortunately, we take this planet for granted, and we have inflicted cataclysmic harm upon it. When I was born in 1964, the world population was 3.2 billion. We're almost 8 billion today. During my lifetime, the global economy and greenhouse gas emissions have both tripled. We as human beings have created a climate emergency, a biodiversity crisis, pervasive air and water pollution, and a surge in emerging infectious diseases of zoonotic origin, such as the terrible COVID-19 pandemic. Yet all human rights ultimately depend on a healthy biosphere and a safe climate. Without functioning ecosystems, which depend on biodiversity, there would be no clean air to breathe, no clean water to drink, and no nutritious food to eat. One mere teaspoon of healthy soil contains billions of microorganisms, algae, bacteria, fungi, and more that feed plants and protect them from pests and pathogens. Healthy ecosystems regulate the Earth's climate, filter air and water, recycle nutrients, and mitigate the impacts of natural disasters. As you know, in India, coastal communities protected by healthy mangrove ecosystems are less likely to suffer deaths during cyclones. Among the human rights being threatened and violated by the global environmental crisis are the rights to life, health, food, water, a healthy environment, an adequate standard of living, and culture. As we have discussed, there are 7 million premature deaths every year because of air pollution, including approximately 1.6 million in India. Hundreds of thousands of children globally under the age of 5 die from air pollution every year. Contaminated water and toxic chemicals kill another 2 to 3 million people every year. For decades, our governments have signed treaties and made pledges to tackle climate change, pollution, and the decline of biodiversity, most notably in 1992 with the UN Framework Convention on Climate Change and the Convention on Biological Diversity. In retrospect, it's an embarrassing litany of bold rhetoric, timid action, and broken promises. Since 1992, global natural gas use is up 82%. Oil use is up 36%. Coal use is up 68%. Overall, greenhouse gas emissions have risen more than 60%. In the 2015 Paris Agreement, nations pledged to hold the increase in average global temperatures to 2 degrees and strive to limit the increase to 1.5 degrees. Yet we are already at 1.2 degrees and are clearly not on track to meet the Paris targets. Similarly, none of the nature-saving targets agreed on by parties to the Biodiversity Convention in the year 2000 were met by 2010. None of the Aichi biodiversity targets were achieved by 2020. And so scientists' warnings have never been more dire or more clear. The Intergovernmental Panel on Climate Change, the Intergovernmental Science Policy Platform on Biodiversity and Ecosystem Services, young people all over the world are all speaking with one voice, calling for rapid, systemic, and transformative changes to human society in order to address the global environmental crisis. And that's why there is a vital and promising role for human rights. In recent centuries, rights have played a role as catalysts for societal transformations, including the abolition of slavery, progress towards equality for women, and the end of apartheid. Rights are being strategically, in many cases, successfully employed by Indigenous peoples, LGBTQ+ peoples, and persons with disabilities. It's never easy or quick or simple, but there can be no doubt that human rights have sparked positive, transformative changes. And in the environmental context, human rights can help overcome the Achilles heel of international environmental law, which is the absence of effective enforcement mechanisms and the resulting lack of accountability. In 2019, the Supreme Court of the Netherlands, in the Urgenda case, ruled that the Dutch government had violated the human rights of its citizens, for example, the right to life, under the European Convention on Human Rights, by failing to take sufficiently ambitious actions to reduce greenhouse gas emissions. Acknowledging the scientific evidence of the severity of the climate crisis, the Supreme Court ordered the government to make faster and deeper emission cuts. And the government has responded to that court order by closing coal plants early, by investing billions of dollars in renewable energy, by putting solar panels on the roof of all schools, by lowering speed limits for vehicles, and more. So you see, environmental law plus human rights equals accountability. Climate cases based on human rights are springing up all over the world. The Torres Strait Islanders filed a case against Australia with the UN Human Rights Committee, arguing that Australia's abysmal record on climate change violates their rights to life, health, and culture. Swedish teenager Greta Thunberg and 15 other youths have filed a similar case at the UN Committee on the Rights of the Child, asserting that inadequate climate action violates their rights. Even more powerful, though, in the context of today's global environmental emergency, is the emergence and evolution of the right to live in a safe, clean, healthy, and sustainable environment. This right was first mentioned at the international level in the Stockholm Declaration in 1972. Portugal and Spain were the first countries to put this right in their constitutions in 1976 and 1978. Today, this right enjoys constitutional protection in more than 100 countries, including India. It's found in the environmental laws of more than 100 countries. It's also in regional human rights treaties, beginning with the African Charter on Human and People's Rights in 1981 and the San Salvador Protocol to the American Convention on Human Rights in 1988. When you add up all of these constitutions, laws, and regional treaties, we find that 156 out of 193 UN member states recognize this fundamental human right. And people ask me, what is the right to a healthy environment? And my answer is that it includes a bundle of both procedural and substantive rights. On the substantive side, it includes clean air, so critical for our conference today. It also includes safe and sufficient water, the subject of a report to the UN Human Rights Council that I just presented this morning. It includes healthy and sustainably produced food, non-toxic environments where people can live, work, study, and play, healthy ecosystems and biodiversity, and of course, a safe climate. The procedural rights include access to environmental information, public participation in decision-making, and access to justice. And the interpretation of this right is guided by key principles that my friend, the Honorable Justice from Africa has already described, including non-discrimination, non-regression, precautionary principle, and prevention. People also ask me, does this right really make a difference? And the answer is unequivocally yes. Research demonstrates that the right to a healthy environment is a catalyst for stronger environmental laws and policies, increased implementation and enforcement of those laws and policies, higher levels of public participation, and most importantly, improved environmental performance. Studies show that countries recognizing this right in their constitutions have reduced air pollution faster, reduced greenhouse gas emissions faster, and provided safe drinking water to a higher share of their citizens. There are remarkable examples from all around the world. Last year, I presented a report to the UN Human Rights Council describing more than 500 good practices in the implementation of the right to a healthy environment, drawn from more than 150 countries. One of my favorites is the Great Green Wall, a wildly ambitious project being undertaken by 21 African nations in the Sahel region south of the Sahara Desert. Billions of trees are being planted, millions of hectares of land being restored for agriculture, water capture systems, solar electricity bringing power to villages. The Great Green Wall will dramatically improve the lives of millions while restoring the ecological health of the region. A few other examples from around the world. Slovenia, a leading proponent of recognition of the right to a healthy environment, decided to get serious about waste management. And they increased the rate of recycling from 7% to 76% of all waste in just over a decade. Slovenia also has protected more than 40% of the country in national parks. Costa Rica is a small middle-income nation with an inspiring story about the right to a healthy environment, which was added to Costa Rica's constitution in 1994. Since then, Costa Rica has reversed a decades-long process of deforestation, doubling forest cover from 25% in the early 1990s to more than 50% today. They've increased the area of national parks in the country to almost 30%. They've passed laws banning open pit mining and offshore petroleum development. They generate 98% of their electricity from solar, wind, hydro, and geothermal energy. They use carbon tax revenues to pay indigenous peoples and farmers to conserve land. And they plan to become one of the first nations in the world to completely decarbonize their economy. In France, the right to a healthy environment was added to the constitution just recently in 2004 as part of a short but powerful charter for the environment. This was a catalyst for the world's first law prohibiting fracking, the world's first national law ending all uses of all bee-killing neonicotinoid pesticides, and more recently, a law prohibiting French companies from exporting pesticides not approved for use in France. France is also, by the way, one of the first countries in the world to explicitly recognize in law that people have a right to breathe clean air. In Argentina, thanks to the right to a healthy environment, billions of dollars have been invested in improving air and water quality in the Riachuelo River watershed, respecting the rights of people living in the poorest parts of Buenos Aires. In Kenya, the right to a healthy environment helped block what would have been a disastrous coal-fired power project in Lamu on the East Coast. In Mexico, the right to a healthy environment was used to block an ill-advised tourism development that would have destroyed a mangrove ecosystem. In the Philippines, the right to a healthy environment was used to stop the logging of old-growth forests and spark a massive project to clean up and restore Manila Bay. A group of Colombian children and youth filed a lawsuit against their government about deforestation. And 2 years ago, the Supreme Court of Colombia ruled that deforestation in the Amazon rainforest violated those children's constitutional right to a healthy environment, ordering the government to work with the children and the country's leading scientists to come up with a plan to end deforestation. I'm currently participating in lawsuits as an amicus curiae in South Africa and Indonesia, where concerned citizens and civil society organizations are arguing that chronic toxic air pollution violates their right to live in a healthy environment under the constitutions of Indonesia and South Africa. Of course, the right to a healthy environment is not a magic wand. It didn't prevent the Supreme Court of Norway from upholding the government's decision to open new areas of the Arctic Ocean for petroleum exploration. It has not prevented catastrophic air pollution in India and other nations where the implementation and enforcement of environmental laws is a monumental challenge. But on the whole, given the evidence I've outlined, it's clearly a catalyst for positive changes. Yet, unfortunately, this fundamental human right is not yet recognized for billions of people. More than 30 countries, including Canada and the United States and China, do not recognize this right. And it's disappointing that it has never been recognized at the global level, where the UN has been debating it since the early 1990s. The good news is that there is unprecedented momentum towards United Nations recognition of the right to a healthy environment. A group of states led by Costa Rica, France, Fiji, the Maldives, Monaco, Morocco, Slovenia, and Switzerland is committed to introducing a resolution, possibly this year, at the Human Rights Council, recognizing everyone's right to a healthy environment. Last September, over 1,000 civil society organizations wrote to the Human Rights Council demanding urgent action. The UN Secretary General, the High Commissioner for Human Rights, the head of UN Environment, and the head of UNICEF have all called for UN recognition of this right. And my friends, it has never been needed so badly. In the short term, the goal is universal recognition of the right to a healthy environment through resolutions at the Human Rights Council and the General Assembly. In the medium term, the right to a healthy environment should be incorporated into a legally binding global treaty, such as a global pact for the environment proposed by France, or a third international covenant on human rights. And ultimately, a right of this importance should be added to the Universal Declaration of Human Rights. States, including India, must not only recognize, but implement the fundamental human right to live in a safe, clean, healthy, and sustainable environment. That means using a rights-based approach to tackle the climate crisis, biodiversity conservation, air pollution, and the global water crisis. We must switch from fossil fuels to renewables as quickly as possible. We must respect the rights of indigenous peoples to the lands, waters, and biodiversity that sustain their cultures while we protect a greater proportion of the world's lands and waters. We must create a circular economy in which everything that humans make and use can be reused, recycled, or safely composted. My friends, with COVID-19, humanity is paying a truly terrible price for ignoring scientists' warnings. We must not make the same mistake again by ignoring climate scientists and ecologists. If we fail to employ a rights-based approach to protecting our environment, future generations will live in an ecologically impoverished
again, sorry
world.
to intervene, but because of the time constraint, if we can wind up, please.
Certainly, I'm just about finished.
Yes, thank you.
If we fail to employ a rights-based approach to protecting the environment, future generations will live in an ecologically impoverished world, deprived of nature's critical contributions to human well-being, ravaged by increasingly frequent pandemics, and riven by deepening environmental injustice. But if we place rights and nature at the heart of the post-pandemic recovery, we can achieve a just and sustainable future. Fulfilling the right to a healthy environment by ensuring people can breathe clean air will help to achieve a range of sustainable development goals, including healthy lives for all, sustainable cities, universal access to clean energy, and effective action to address climate change. Thank you very much.
Thank you, sir. Thank you for that insightful address. You have adequately emphasized on the urgency and the magnitude of the issue of air pollution from a very solution-based policy deliberation. Thank you very much for that. Now to move on to the next speaker, who will be speaking about the evolution of the US Clean Air Act from fighting pollution to fighting climate change, I would like to call upon Professor Kirsten Engel, Arizona State Senator, US. Dr. Engel is the Charles E. Ayres Professor of Law at the James E. Rogers College of Law, where she teaches and researches in the area of environmental and administrative law. The emphasis of her more recent scholarship is the response of state and local governments to climate change in the United States, and especially the constitutional and economic impediments these governments face seeking to mitigate climate change in the absence of comprehensive federal climate change legislations. Professor Engel is also the co-author of an environmental law textbook, book chapters and articles. Her works appear in journals such as the UCLA Law Review Discourse, the Minnesota Law Review, and the Ecology Law Quarterly. Prior to joining the law faculty at the University of Arizona, she held numerous permanent and temporary appointments within academia and in the public and nonprofit sectors, including the US Environmental Protection Agency, the Massachusetts Attorney General's Office, and Harvard, Vanderbilt, and Tulane Law Schools. It is an honor to have you with us and address the forum this morning. A very warm welcome to you, ma'am.
Thank you very much. And you can hear me?
Yes.
Yes, okay. Well, it is quite an honor to be part of this symposium on such a very, very important topic. And it really closes the distance between our countries to talk about an issue of clean air and the right to a healthy environment, because I think that that is what brings us all together and shows the connections of between us in terms of what we need to be able to live a healthy life on this planet. So I think my talk is going to be a little bit different than the talks that you have just heard from the other speakers, but I will try to make it relate to this to these very important issues of clean air by also talking about the challenge of climate change that we're facing today, and how, at least in the United States, the fight for clean air is helping us to fight on the issue of climate change. And it's really, I think, a story of what are some of the possibilities and the potential of what one must do in the absence of having a strong international programs and rights that one can rely on. So in the United States, as I'm sure everyone knows, the US has not been willing to sign on to the more recent climate change international accords. The United States is a party to the 1988 Intergovernmental Panel on Climate Change for doing scientific research on climate change. The US is a party to the 1994 United Nations Framework Convention on Climate Change. But very importantly, the United States signed but refused to ratify the Kyoto Protocol back in 1997. And since then, and we will talk about that more, the United States signed and joined the Paris Climate Accord, but then left that accord under the Trump administration. And today, finally, the new President Biden administration is putting the United States back into the Paris Climate Accord. For many, many years, however, the United States has not been really part of anything very strong on the international level in terms of climate change, and nor has our national government passed any kind of comprehensive climate change legislation, even though year after year there has been an effort to pass some kind of climate legislation. Especially in the early 2000s, there were many proposals for some kind of national cap and trade program. The story I want to tell, however, is about how the Clean Air Act became a vehicle to address climate change in the absence of having being part of a strong international climate accord or having national standards. The United States passed in 1970 the Clean Air Act. It's a national act. And for its time, it was a very modern statute. And people have looked at it as really almost a piece of human rights legislation. One of the most important provisions of the act, Section 109 of the act, requires the Environmental Protection Agency, the federal agency, to establish national ambient air quality standards. And these are maximum standards for pollutants in the ambient air. And the standards are to be established according to what is needed in terms of protecting health. And I'm just going to read the standards that specifies that the administrator shall set a standard, the level of which to attain and maintain in the judgment of the administrator based upon scientific criteria are requisite to protect the public health. And there are many court decisions that interpreted this provision to have a precautionary principle, much like the international, what you find in international environmental law, the precautionary principle that we should be very careful and not require certainty before regulating in order to protect health. That as long as there is some evidence of endangerment of public health, that is sufficient for the regulation. The Clean Air Act was used successfully to address terrible air pollution in many of the United States' biggest cities, especially Los Angeles, Chicago, New York, up and down the East Coast of the United States. Well, when there was no action on climate change, environmental groups got together, and in 1999, they filed a petition with the EPA to say that greenhouse gases should be regulated under our Clean Air Act, that in fact the emission of greenhouse gases endangered public health and welfare. And this was a novel interpretation and a novel theory, and it was, they made this argument in order to try to compel the Federal Environmental Protection Agency to regulate greenhouse gas emissions from motor vehicles. And of course, in regulating greenhouse gases from motor vehicles, you not only address the issue of climate change, you of course also address the pollution issue, since those greenhouse gases come from the combustion of fossil fuels, which has, of course, all of those other pollutants that come with it. So they were using actually a very similar part of the statute, just a little bit different than what I just described, a part of the act which requires EPA to prescribe standards applicable to the admission of air pollutants from any class of motor vehicles, which in the EPA administrator's judgment causes or contributes to air pollution, which may reasonably be anticipated to endanger public health and environment. So these environmental groups got together and they petitioned EPA to list greenhouse gases as a Clean Air Act pollutant. And of course, the act had never been used this way. It had only been used for more conventional air pollution problems. The EPA refused, and several states in the United States appealed that ruling to the United States Supreme Court. And they argued that under the broad definition of what an air pollutant was under the Clean Air Act, that greenhouse gases were covered by the United States Clean Air Act. And in a 5-4 decision, the United States Supreme Court agreed, and that is the Massachusetts versus EPA case. And they read into a very, very broad definitional provision under the Clean Air Act about what was an air pollutant. And of course, in 1970, it wasn't so clear that the United States Congress was thinking about greenhouse gases. And yet, there was a very broad definition in that statute, which said that an air pollutant was any physical, chemical, biological, or radioactive substance or matter which is emitted into or otherwise enters the ambient air. And so the environmental groups used really a growing tradition at the time of statutory interpretation of just looking at the plain language, not actually looking at necessarily at the intent of the drafters of the act, but instead what could be encompassed within this broad definition of this health-based federal Clean Air Act. And they argued that it did cover greenhouse gases. And in a very, very narrow vote, the United States Supreme Court agreed. After that time period, the next step is not only does the act have to apply to greenhouse gases, but also under the act, they have to be found to endanger public health and welfare. And in the mid-2000s, under the Obama administration in the United States, there were a series of rulemakings. The EPA did a very large and very comprehensive scientific rulemaking in which it determined that yes, the emissions of greenhouse gases do endanger public health and welfare. It is a 100-page, very dense decision full of scientific papers and citations that was issued in 2009. And once that occurred, once there was a determination that emissions of greenhouse gases endanger public health and welfare, that opened up all other parts of this Clean Air Act to be able to be used to address the problem of greenhouse gas emissions. And this included rulemakings dealing with new motor vehicles, oil and gas generators, coal facilities, methane emissions from oil and gas facilities, and ultimately resulted in a bilateral agreement between the United States and China to reduce their greenhouse gases. And in the Obama administration in 2016, that was the basis upon which the Obama administration signed the Paris Climate Agreement because it then had enough domestic reductions in greenhouse gases pursuant to these various rulemakings under the Clean Air Act to be able to say that they could reduce those greenhouse gases. And of course, so many air pollution problems, I want to emphasize, are so directly related to climate change. It's very hard to distinguish between the two. When we talk about moving toward a clean energy economy, this is one in which we can protect our health by having fewer air pollutants and also be reliant upon renewable energy and energy efficiency in order to reduce our reliance upon fossil fuels. So at this time, I think that there's a sort of lesson here in that you may not always be able to rely on the international agreements if countries, for various reasons, political reasons, etc., are not willing to engage in the international dialogue and agreements in the international arena. Of course, I very much support that, but I've labored in the trenches here in the United States when we could not rely upon those international agreements, and we had to be creative about what domestic authorities we had, and then, as you can see, use that to then get back on track to being able to join those international agreements. Today, I both teach at the University of Arizona. I'm also a state senator, as was said in my introduction. And the United States is very decentralized in certain ways about environmental protection. And it is still very much, very large battles are still going on with respect to clean energy. And I have to report that in the state that I'm in, Arizona, has not been very proactive, even though this is a state that is feeling the effects of climate change and its pollution. Some of the largest cities here, Phoenix, that's the city where I am in right now, has real problems with air pollution. And there has just been record-setting temperatures over the past couple years, especially last year's many record-setting wildfires and drought conditions that we are experiencing in the Western United States. And tomorrow, interestingly enough, we will be debating in the legislature of the state of Arizona a very significant bill. Unfortunately, it's kind of, in my opinion, not a good bill, in which we have a battle going on between the legislature and an appointed commission over clean energy rules. So at this time, I would be very happy if we could have more reliance on, if we could build and strengthen our international standards and our international commitment to the right to a clean environment. I think it would be very important because it would be something to turn to while we are still working toward those goals. So that concludes my presentation. Thank you again for having me to such a distinguished conference. And I would like to learn more from the other panelists about how we can accomplish this together.
Thank you. Thank you very much, ma'am, for your expert comments from the US legislative perspective on the topic of fighting pollution to fight climate change. Thank you very much. Now to move on to the question and answer session, and to moderate the question and answer session, I would like to invite Dr. Sujata Arya, Assistant Professor, Symbiosis Law School, Pune.
So very good morning to all the participants and the dignitaries. And we've had a very enriching and a diverse perspective that we've heard from all the panelists. So starting with our director, Dr. Shashikala Gurpur ma'am, who set the tone with the history behind the right to clean air, the importance of sustainable goals, the right to clean air in India. We've had Justice Emmanuel, who spoke about evocative stories about the impact of climate change and an unhealthy environment on people, especially young children, the role about the judiciary and the various principles like non-regression, polluter pays principle, access to justice. And then we had David Boyd bringing out a very important point about linking and the nexus of human rights with climate change. And then we've had Professor Kirsten, who also has brought out about the need of climate legislation in various countries, the need for clean energy rules which are required, as well as about the evolution of clean air in the US. So now to start with the questions to the various panelists, the first question which was asked by Mr. Sandeep, and he has put in an article in the chat box, and then he has asked this question that whether the apex authorities claiming to be flag flyer of environmental protection are that serious about it. And the question is whether it would be advisable to the UN or other authorities to lay down self-regulation on their own representatives so that CO2 emissions will not be increased by air travel and then trickle down to the other subordinates. Mr. David Boyd, if you would like to take that question, please.
Yes, thank you very much for that question. And I would say that, if there are any silver linings to this terrible COVID-19 pandemic, one is that we have all learned that we can actually have amazing conferences like this conference on the right to breathe clean air in a virtual setting. And we have saved countless tons of carbon dioxide, countless hours of flying and time and exhaustion by having this virtual conference. Now, we can't have all conferences virtually in the future, but I think that there's no question that, when we talk about environmental conferences in particular, there's no need for the amount of flying that was being done prior to the pandemic. I went to a conference of the parties to the UN Framework Convention on Climate Change in Madrid in 2019. And, there were close to 30,000 people there. That's an enormous impact on the planet. And so I think that going forward, we should reduce the amount of air travel we engage in, and we should do more of these virtual type meetings. So I agree with the question from the floor. Thank you.
Justice Emmanuel, Dr. Gurpur ma'am, Professor Kirsten, would you like to add?
I would just have to agree. It's very unusual to have like an entire year without going to a conference or to talk about the environment. And yet, with the exception of possibly being able to purchase carbon credits along with your airplane ticket, there was really no way in order to recognize really the impact on the environment of simply the travel. And air travel, we know, is very polluting. I think that, step one is always to look within yourself, look within your own organization and the ways in which you might be able to reduce your impact on the environment within your home, within your school, your university. And this is a great place to start. I still think we miss something in not having the direct human contact. So I would not want to only do Zoom conferences when we talk about the environment, but certainly we can be much better and more responsible in terms of using technology to communicate and work on environmental issues.
Thank you, Dr. Kirsten.
Yes, let me also agree with my fellow panelists. As the president of the court, I tried to bring in place the idea of resolving cases via the technology that we have. Given that the parties are spread all over East Africa, it's an East African Court of Justice, and the members to the East African community are 6 countries. it was faced with a certain level of resistance until COVID came into this big picture. And as a result of COVID, from March last year, before I exited the services of the court, we have managed to deal with most of the cases. But I think what COVID has taught us, and the use of technology in having conferences and dealing with court sessions, is we now have a clear picture on what can be done via technology and what can be done via face-to-face. I agree with my fellow panelists that not every conference or every proceeding should be held via this technology that we have. But a lot more can be achieved via the technology and cut significantly on the hours that we use to fly and our carbon footprint.
Thank you, Justice Emmanuel. Purpur ma'am, would you like to add?
Yeah, I would like to suggest to you that let us dash off questions to the panel. First of all, I really liked some of these questions. One is whether there should be a ban on private jet. Second is they are talking about how the link between the particulate matter or the pollutant emission and air quality is a very complex link, which is also depending on sunlight and other kind of changes. So what Vice Chancellor pointed out earlier in terms of investment in waste management technology, somebody was asking, one of the audiences was asking about access to cheaper technology. Probably Professor Boyd should be answering this question in the global policy level, and also Justice Emmanuel and legislator Engel, whether there should be a global agreement on this or compact on this, which will talk about cheaper waste management technology or affordable waste management technology to be accessible, and also the banning of these jets, private jets especially, rerouting of air routes in such a way that there is a lot of saving on the fuel or less of emission. Then the other idea is how domestic law can build on these international conventions and laws. My personal opinion is that I do agree with the legislator and Professor Engel that lifestyle changes that each one of us makes, it will mean entire urban management in terms of what we call as the blue zones, you know, the pollution-free cities in terms of cycling zones. Indian cities need a lot of overhaul. Therefore, it's an integrative approach, not just confined to emissions and prevention of emission. It's also long-term strategy and short-term strategy. That's my response. Thank you.
Thank you, Gurpur ma'am. So the second question is from Swecha Malik, and she's asking that even though Paris Agreement has been ratified in 2016 by India, but still we do not have a climate change act that specifically deals with global warming. And should a specific legislation enactment help to control climate change? Dr. Gurpur ma'am, would you like to take that question?
Let it go to the important. I mean, as far as India is concerned, we have the policy in place, which is still a work in progress. We already have Air Pollution Prevention and Control Act. We could revamp that act and call it as Right to Breathe Clean Air Act. So we hope that there is a whole lot of deliberation going to come, paper presentations going to come this, I mean, in the next part of this program, and also tomorrow extensively. So based on that, we'll drop certain guidelines and ideas for this. We welcome your response also in the chat box. Thank you.
Would any of the other panelists like to add? Otherwise, we can move to the next question from Astha Pitle. Yes, Dr. David.
Yes, thank you. Well, a couple of thoughts. One is in response to this suggestion that there should be enhanced efforts made by wealthy nations to address the technology gap between the North and the South. And I agree with that 100%. I think that wealthy nations have made commitments over the years, which they've never really lived up to in terms of both financial assistance and capacity building and technology transfer. And I think that that should be happening at a much higher level. Under the Paris Climate Change Accord, wealthy nations committed to provide $100 billion a year in financing for climate mitigation and adaptation. They have not yet met that target, and I think it's a moral imperative that they do meet it in the years ahead. And I would also say that I love the idea of India having a Right to Breathe Clean Air Act. I think that would really catapult India to the forefront globally, at least on paper. And then the big challenge, of course, would be to ensure that that law is not just a paper tiger, but that that law is rigorously implemented and enforced so as to improve air quality for all of India.
Thank you, David Boyd, sir. So we have another of our esteemed guest, Dr. Bharat Desai, sir. Dr. Boyd would like to ask a question to you. Dr. Desai, sir, please go ahead.
Well, yeah, good afternoon to everyone. I just had the pleasure of listening a little bit, tidbits of something in the fag end of this session. But I thought, let me ask. I heard with pleasure what Kirsten Angel said and also what Mr. Emmanuel said. But to specifically to David in the fag end of this session, I thought since you happen to be the UN Special Rapporteur on human rights and environment, probably I think knowing very well the remit and the mandate of the UN Special Rapporteurs, the way in which the sovereign government they treat, including my own government, series of those UN Special Rapporteurs, how they did. But notwithstanding all those things, we are talking about international limits of law, or limits of both domestic law and limits of international law. But notwithstanding that, the human effort could be limitless. So what I'm suggesting to you, probably I do not know what within the limits of your mandate and what probably at the end of your thing you will be able to put forward to the Human Rights Council is a possibility in terms of something concrete, what something gist which has come out, that well we will of course talk about these hi-fi things, the Paris Accord and other things, what happened to the the Kyoto Protocols, the so-called Kyoto Protocol, I would call it so-called Kyoto Protocol. The Kyoto was dead, and as they said, long live the Kyoto Protocol. So this has been there, what the strong nations they will try doing it. But I think probably even you will be addressing to the UN system and maybe even to the sovereign state, probably something will critically lie at the level of the human behavior. What Gandhi had himself said, that if you want to see the change, you be the change. Let us not talk. So probably somewhere like of course your direct suggestion could be to the UN system and to the UN states, the member states of the United Nations. Probably something with respect. Now the time has come, to ask something specifically to bring about the behavioral change, lifestyles, the consumption, the production, the wastage, So probably I would say little bit, maybe even I would say like what the people call, the judges will call it like a obiter, even at the risk of being reduced to obiter dicta, something to be placed on record. Probably I think will be worth it. I do not know what you have done. I was planning to to be in touch with you, to write to you, but I thought since it's a right occasion, it has gone. I thought a little throw little idea, and love to hear from you. Yeah, thank you, David.
Thank you very much. Well, I think your point is really getting at the fact that we can't put all of the responsibility onto governments for changing the world that we live in. We also have to take personal responsibility, and I concur with that. In my reports to the United Nations, I not only have recommendations for actions by states, but also recommendations for actions by businesses, and also recommendations for actions by individuals. So, but I would put them in that kind of a hierarchy, that we actually need governments to set in place rules and systems that allow individuals to make decisions that are not only good for themselves, but are good for the planet. And a classic example of that is probably something that we all do a number of times every day, which is we choose what we're going to eat. And I think that, it's clear from the scientific evidence that humanity, with a population of almost 8 billion headed towards 10 billion by the middle of the century, we need to eat a predominantly plant-based diet. Now, of course, there will be exceptions to that. The Inuit in the north of Canada are not going to eat a plant-based diet. But for the majority of people, a plant-based diet is the healthiest for humans and the healthiest for the planet. So that's something that individuals can choose to do, but states need to put in place laws, regulations, and policies that make that the default choice, that account for the externalities, the enormous externalities, for example, of the intensive industrial livestock operations that are growing in many countries around the world, that account for the massive externalities of industrial agriculture. And so that's where public policy and government action is critical. That's where we have to hold businesses responsible for their actions. And that's where people can also make individual choices to help turn this giant ship around and move us towards a sustainable future.
Thank you, David, sir. As we are running short of time, this is the last question to the esteemed panelists. How would you respond to the argument that the developing countries are being unfairly penalized for the current state of air pollution in comparison to countries which have already developed by taking advantage of industries which have caused a great deal of air pollution themselves?
Well, I would say that I would agree with that comment. That certainly is the case with respect to climate change. We are all feeling the effects of the 100 years in which developed countries have been pushing along, building their wealth and polluting the air and creating that buildup of greenhouse gases. So I think this directly points to the technology transfer and the assistance that developed countries owe to developing countries in terms of adapting to climate change, which is a huge issue of itself, because there's so much that we cannot at this point stop in terms of the impacts of climate change. So I guess I would agree with that, and that we have to make sure that we right that ship, and there is some justice and equity in terms of how we move forward.
Thank you, Dr. Kirsten. Justice Emmanuel, sir, if you would like to add something.
Yes, thank you very much. I'm a very firm believer of what is commonly known as common but differentiated responsibilities towards protection of the environment. We all have that common goal of protecting the environment, but more burden should be on the more developed countries because they have the resources, be it the technology and all that. And it answers to the question earlier posed by Professor Gurpur. I think there's technology which is becoming cheaper and cheaper every day, which is available in the mostly developed countries. And I think it's high time that there should be equitability when it comes to using this new and cheaper technology, and even making it much more cheaper in order for people in developing countries to be able to access the technology. We all need energy. That's an obvious question. I mean, when you go to the rural areas in Africa or in Asia, it is true that everyone requires energy for their livelihood. But how do we get that energy? That's the bigger question. I do believe technologies are there. They should be made even much more cheaper. And this can be achieved if all of us have this common goal towards the protection of environment, but also recognizing that we have differentiated responsibilities towards achieving environmental protection.
Thank you so much, sir. With this, we come to an end to the question and answer session. We thank all the participants for having a very deliberative session and asking the question to the panelists. We also thank Dr. Bharat Desai for joining us and for his comments. And we also have a comment from our another speaker, Dr. Valentine, who has just again highlighted that we are dealing with a complex link between air pollutant emissions and air quality, which include emission heights, chemical transformations, reactions to sunlight, etc. So thank you very much, one and all. And I now hand over to Lasya.
Thank you, Dr. Sujata, for moderating that session, and thank you to all the speakers and the participants for such excellent questions. Now, I would like to invite Dr. Bindu Ronald, Deputy Director and Professor at Symbiosis Law School, Pune, to deliver the vote of thanks.
Thank you very much, Professor Lasya. As we come to the end of the inaugural and the first plenary session of the virtual conference on right to breathe clean air, health and environment-related SDG, I, Dr. Bindu Ranur, on behalf of Symbiosis Law School, Pune, have the privilege to thank all those who have contributed to making this event happen. We are extremely happy that we are able to bring to you this two-day conference specially designed to discuss and deliberate on the various interdisciplinary areas and the core issues pertaining to the right to breathe clean air in the light of Sustainable Development Goals. There are many on my list who I have to thank, and I must begin by thanking our chief guest, Dr. David Boyd, UN Special Rapporteur on Human Rights and the Environment and Associate Professor of Law Policy and Sustainability at the University of British Columbia, Canada, for accepting our invitation to be part of this virtual 2 days conference. Also, thank you, Dr. Boyd, for consenting to be the panelist for the first plenary session, speaking to our audience on the subject, the emergence and evolution of the right to a healthy environment and implications for clean air. I place on record that this conference is the result of the prestigious conference grant, which was awarded to Symbiosis Law School, Pune for the year 2020-21 under the Golden Jubilee Conference and Lecture Series grant from the Shastri Indo-Canadian Institute after a nationwide competition. I thank Dr. Prachi Jain, Director, Shastri Indo-Canadian Institute and representative of the Shastri Indo-Canadian Institute for being part of this inaugural session and addressing the audience, and definitely her presence meant a lot to all of us. Our top management has been extremely supportive of all the endeavors of the law school, and it is evident in the presence of our Chancellor, Dr. SV Musumdar, founder and Chancellor, Symbiosis International University, at the inaugural function. A leader par excellence, we've always felt a special warmth and inspiration every time he graces our events, and I thank him for being part of the inaugural function. A special thanks to the Vice Chancellor of Symbiosis International Deemed University, Dr. Rajni Gupta, for gracing the occasion, and I also thank our Pro-Chancellor, Dr. Vidya Yerudekar, for her support and excellent leadership. We are delighted with the presence of Justice Emmanuel Ogirashebuja, former President, East African Court of Justice, speaking on the subject, right to breathe clean air and sustainable development goal, the role of judiciary, and bringing out the essence of the role of judiciary and highlighting the issues before the court on the topic. And our other panelists this morning, Professor Kristen Engel, Arizona State Senator, who spoke to us on the evolution of the US Clean Air Act from fighting pollution to fighting clean air and introducing the audience to the issues relating to the topic. We are happy to host all our panelists who will be part of the parallel tracks that will follow this plenary session and thank them for their presence. We will have in the different tracks Professor S. Santakumar, Director, Gujarat National Law University, Dr. Bharat Desai, Professor Jawaharlal Nehru University, Delhi, India, Dr. Sairam Bhatt, Center for Environmental Law Education, Research and Advocacy, National Law School of India, University, Bangalore, Dr. Valentin, Senior Science and Program Management Officer of UNEP and Climate and Clean Air Coalition, Dr. Prakash Rao, Deputy Director, Symbiosis Institute of International Business, Pune, Mr. Siddharth Singh, Lead Country Analyst and Coordinator, India International Energy Agency, Mobility Climate Policy Expert, who will all be contributing to the two parallel tracks that will follow. Dr. Shashikala Gurpur, Director, Symbiosis Law School, Pune, is the person who spearheads every initiative at the law school. And in the last 14 years with her as the director, Symbiosis Law School, Pune has achieved many accolades, reached milestones, and going strong. Thank you, ma'am, for your vision and guidance in organizing this conference. All the participants and paper presenters on the different tracks need a special mention, and it also includes all the students who are participating in this conference. I also thank all the faculty and staff for their untiring support, without which an event this magnitude would have been difficult to organize with precision. Here I place a note of appreciation for the contributions of Dr. Rupal Rao Desai, Dr. Aparajita Mohanty, Professor Raj Verma, and Ms. Aditi Mani. Our IT team needs a special mention. Their contribution and backstage work is what has made this virtual conference a success and made it possible for people from different continents to come together and participate in this intellectual feast. Thank you one and all for being part of this conference, and we hope that you will have a wonderful time in the sessions to follow. Thank you. Thank you very much.
Thank you very much, ma'am. With this, we come to the end of the first plenary session of the virtual conference on right to breathe clean air, health and environment-related sustainable development goals. Before moving on to the parallel tracks, we will be taking a 5-minute break. So I request all the speakers and participants to stay connected to the link, as you will be redirected into breakout rooms for the parallel tracks by our IT team. The themes for the parallel tracks are international law perspectives on the right to breathe clean air in light of sustainable development goals and global best practices in tackling air pollution. So there is much to look forward to, and we will return in 5 minutes' time. Thank you all very much.
Thank you. Thank you, esteemed panelists. Hope to partner soon in many ways. And thanks, Professor Desai, for being a friend in need and friend indeed. Thank you. Thank you all. Thank you, faculty. We'll revert.
Thank you very much. Those were very, very powerful presentations. Very good to join you.
Thank you, everybody. Really great.
Thank you. Thank you, Justice. Thank you, Boyd.
Thank you.
Yeah. Thank you for compromising your sleep and your time. Thank you so much. We are indebted to you, truly. Thank you.
Okay.
We continue with this, Shashi?
So you'll be directed to the breakout rooms soon. We will take a 5 minutes break, but we'll remain on the link.
Okay, the session got late, because I had already, there is something contingency. I had given time to somebody, so.
Yes, sir. We'll join. We'll just have a 5 minutes break.
So once I complete my present, maybe whatever the time, then maybe I'll need to leave. I won't be able to stay on in the session.
Sure, sir.
Huh? Okay. Sure, Rupal Ben. Sure.
Yes, sir. Thank you for joining us, sir. Yeah, it's wonderful, sir, to have you. So just 5 minutes, sir. Now just 4 minutes.
પણ મને હતું કે 12:15 વાગે શરૂ થઈ જશે કીધું તો પછી પૂરું નહીં ક્યોંકि 1 વાગ્યાની આસપાસ મારે કંઈક યુનિવર્સિટીમાં બધું બહુ ચાલે છે ને I thought I'll then leave.
Right, sir. Right, sir. We understand, sir, completely. Definitely. So we'll begin in 2 minutes, sir.
પછી બાકી બધા મોટા માણસોને જે વાત કરવી ભલે કરે પછી આપણે હું પછી નીકળી જઈશ હે ને મોટા માણસો મોટી વાતો કરે ને પછી આપણે બાકી મજામાં
did a
Excuse me, ma'am.
Hello. Huh. But I'm already online.